I'm not that old yet. I got angry earlier. It happens. But I want to ask you, is that what you did to my Mike Harrington? Did you take my Michael Harrington, do something you weren't supposed to do? See, I've been kind of pissed for a while, and I've expressed this several times. I feel like somebody decided they were going to make me their little other America test case. If they were going to bond me, or they were going to run some process on me where they tried to make me poverty in Appalachia. And not so ironically, we're in a strange period in American history with the so-called opiate epidemic. A lot of focus was paid to the opiate epidemic at some of the stages of the prosecution for what is alleged to be the context of the opiate epidemic regarding its relationship to communities in Appalachia. A lot of these communities, by the way, are along a highway system that right now is under major construction. And I believe this is not unrelated. But I'm not going to talk too much about that, except to say that I've identified that the opiate epidemic, at least litigiously, including insofar as it includes several alleged, at least, congressional hearings, has had 4 major stages. And I believe that at least the last 2 reveal that the first 2 were rather misguided at best. For instance, I've come across information about how in the prosecution of the opiate epidemic as it took place in Appalachia, among the things that happened were a case where there was a request for production of information from the respondent in the case, the defendant. And in the course of this, the defendant in the case ended up having some sort of conference with the judge and said to the judge that they were going to provide the information, but only a certain kind of information presented in a specific manner. They then talked about how they kept filing motions to delay the production of this information. It just so happens the delay in the production of that information, it's a very important timeline when it comes to SEC filings, including quarterly filings, but also other kinds of disclosures that one must engage, insofar as there is a litigious action that requires substantial change to the understanding of earlier stock offerings, how there might be some sort of change in regard to information that's come up. That means they may not be able to deliver on what they had originally promised. As a matter of fact, there have been 2 cases that have gone before the Supreme Court of the United States in the last 12 years that speak to this very specifically. They were 10 years apart. And the course of this context wherein these cases were 10 years apart, there was also significant information and context regarding those particular cases that went all the way to the Supreme Court that shed light on what my concerns are in regards to this particular information. I would identify the primary cases that happened in connection with the Appalachian opiate epidemic as being part of stage 2 of a 4-stage process regarding efforts to try to prosecute the opiate epidemic. And one of the reasons why the later 2 stages, including the most recent stage, have been misguided. As a matter of fact, in late 2018, prior to the congressional confirmation of Kavanaugh to the Supreme Court, I had actually composed a follow-up to an earlier proposal I had for a series of efforts to prosecute the opiate epidemic in the context of state cases associated with investigating and auditing the implementation of the Affordable Care Act, specifically in connection with the state marketplace mandate, to assure against using health care under the context of the state marketplace aspects of the Affordable Care Act as some form of competitive bidding scheme that actually violated the law in manners comparable to what I was trying to charge here in Texas in consideration of cases I had filed first to the state, then to the district court, and attempted to appeal to the Supreme Court of the United States. This was in, I think, August, September 2018. I had a complete outline of a preliminary outline of how to start this. And I actually, by the end of 2018, contacted every attorney general's office that had identification available through a National Association of Attorneys General. I contacted every office individually with the request that they consider not only the recent announcement that the Supreme Court of Texas was referring a case to the Supreme Court of the United States regarding the Affordable Care Act, but also that they consider my allegations about the connection regarding the Affordable Care Act, implementation of the Affordable Care Act, and situation ongoing at that time with the opiate epidemic. At that time, I only got a response from one state's attorney general, which I won't mention here, and I did have some communications with him. Unfortunately, I have to say, I wish I had been able to have other communications with him and or other states' attorneys general. That fortunately, they did not get back to me at the time. I feel this is a very missed opportunity. However, I say this because that would have been my contribution to following through on and in the legacy of Michael Harrington, including insofar as I read Michael Harrington's work. As a matter of fact, I was a big fan of Michael Harrington. I used to have his books in my library. It was ironic to me how I had the relationship with Michael Harrington, especially relative to other people who consider themselves democratic socialists in the United States. But I was also in the National Political Committee of the Democratic Socialists of the United States at a time when many people my age were still in college. And so they were in the youth section while I was actually doing work on the national level. The thing about the National Political Committee of the DSA, the Democratic Socialists of America, is that it's also a board of directors of a nonprofit organization. Tactically, or at least practically speaking, in the United States, organizations such as that form is a 501c3. And so members of the National Political Committee also have the legal responsibilities as members of the board of directors. That includes the fiduciary responsibilities. And the thing about the Democratic Socialists of America, and specifically the relationship with Michael Harrington, is that Michael Harrington wasn't the only founder of the Democratic Socialists of America. It was formed as a merger of two other organizations, including one he'd been very instrumental in, the New American Movement and the Students for a Democratic Society. And so when they ended up merging, they formed the Democratic Socialists of America. But when Michael Harrington died, he had bestowed through his estate onto the organization, his estate. So he had actually gone through a legal process that would have been applicable under a state law in the United States to bequeath, to bestow onto the organization itself, his estate, so that it could be used in connection with financing and supporting the operations of the National Political Committee of the Democratic Socialists of America, but the Democratic Socialists of America overall. I kind of wish I knew more about trust law, because it was through a trust that he did this, and I kind of wish I knew more about estate law, because I was asking myself, and I was asking others, insofar as I do, what was the expectation of members of the National Political Committee to allow for their estate, not just for political reasons due to the actual political commitments people in the organization made as a member of the organization, including on the NPC, but also in terms practically of understanding that we were in a situation where we were on the board of directors of an organization wherein one of the major funding sources was the bequeathing of an estate of one of the founding members. Was there an expectation that we ourselves were members of that trust, and so that contributions we made to the organization were allowed to be considered some form of trust in connection with later activities by the organization? Nobody answered this at the time. Nobody talked about it at the time. And sometime later, I ended up working for a real estate and a family law attorney that actually did things like make trust agreements. And I've since had reason to re-examine that, and I've done some research, including here in the state of Texas, specific to Texas, but not exclusive to Texas, regarding what actually happens with an estate, including intangible contributions to an estate, including the consideration of intangible property, and what it means for consideration of belonging to a trust or being a beneficiary of trust versus being somebody that would be a trustee. And so the question of the relationship of who would be considered the trustees of Michael Harrington's estate, insofar as the estate was bestowed onto the Democratic Socialists of America to be presided over by a board of directors at a 501c3 that also functioned as a national political committee, right? I bring this up because as angry as I get about this whole situation where I'm supposed to be some sort of like Appalachian test case, you know, the whole Irish American and our predilection for drugs and alcoholism, and how poverty in white America somehow is different than poverty in urban America, including in its racialized context. Well, what did you expect for somebody that would have been the beneficiary of, or even a steward of, the trust of someone like Michael Harrington to do if confronted with the opiate epidemic in Appalachia? It might call into question other things that would have to do with an understanding that the opiate epidemic in the United States is part of a long legacy of the so-called war on drugs. And it also has to do with the fact that around the time Mike Harrington was bestowing his trust onto the Democratic Socialists of America, there was another trust that had been engaged by the federal government. It was called, if I'm not mistaken, the Trust for Drug-Free America. It was a youth trust. Presumably, there was a bill that passed, and there was supposed to be appropriations for what was called a youth trust for a drug-free America. My understanding is this trust was passed in 1986. That means that by that time, I would have been under 10 years old. But as part of the DARE program that was engaged in conjunction with former First Lady Nancy Reagan, it was understood that educational activities connected to the DARE program also included people that were in grade school. They weren't just for high school, and they weren't just for college. They started trying to do this sort of drug education programming and educational efforts in grade school. Now, I don't recall personally ever going to a grade school that had a DARE program. I grew up mostly on military bases. To be honest with you, I don't even remember being exposed to anybody who even did drugs or knew drugs until I went to college. So it was kind of a different context. I don't know about people that went to public school and how many people were exposed to DARE programs, including when they would have been grade schoolers or even if they had been junior high or high school. But I do remember that as part of the DARE program and in conjunction with the DARE program, there was a period of time during the 1980s where at the time there was a concern about kidnapped children. And there was a lot of programming that was going on, the commercials on television, things that were going on, that were talking about how the FBI had compiled a database to create fingerprint cards for children in the event that they got kidnapped. And at one point in time, I remember my mother took my sister and me to a local mall where they were doing a special event over the course of a weekend where you could take your children to get these fingerprint cards. And the understanding was you went and you got fingerprinted, and you kept one of the copies of the fingerprint card, and the other copy of the fingerprint card went to the FBI. Well, the thing is, a fingerprint is also a biometric identifier. And in 1986, 1987, they weren't talking about biometric identifiers. To be honest with you, this happened earlier. This happened, if I'm not mistaken, sometime around 1984, maybe 1985, because by 1986, I had moved somewhere else. So this happened prior to that move in 1986, between 1984 and 1985. I've long wondered what happened to these fingerprint cards. That means they would have had, FBI would have had a fingerprint card, which would have been my primary biometric identifier information, since before I was a minor and before they actually implemented the Youth Trust for Drug-Free America. Now, I never heard about this growing up. I've only heard about it in the last couple of years. I've researched the legislation. I've also researched other documentation regarding congressional reports in connection with the early onset of the Youth Trust for Drug-Free America, and I don't know what happened to it. But in 1986, there were also changes to the Tax Reform Act that had to do with identifying children and the revenue potential of children insofar as they were considered for taxation and the relationship between the child and the parent when it came to information about the taxation concerning the revenue potential of a child. Now, I've contended for several years, and I've actually been doing this for a couple of years. I actually more recently actually identified this in a process of attempting to implement some sort of injunction on an ongoing process that should not have occurred and may be relevant right now. I've contended those specific changes to the tax code, at least publicly on my blog, since around October, November 2019, they should be changed. They should already have been changed. As a matter of fact, they should never have been allowed to have been put into the tax code. And so far as I understand, they're still active. And I contend it is one of the most unsecure things that the United States has ever done when it comes to providing for the safety and welfare of children, that it has been horribly abused. And in the course of it being horribly abused, it is one of those things that is kind of obscure unless you know how to look for it and unless you found it and know about it. And I contend that there are those who know about it and they have used it for malevolent purposes. They've used it in exploitative purposes. And actually allowing for it to be changed could be one of the simplest ways to actually stop a lot of what's been going on in the processes of engaging these regimes of exploitation of children. There's some reason somebody made a justification for not only keeping quiet about that as an issue, but refusing to change it. And it's not just about tax waivers or trying to get out of paying your taxes. As a matter of fact, when people talk about how we need to increase taxation on the rich to get the rich to pay more of their share, I think it's disingenuous when they don't also say, well, first we need to disengage this process of understanding this particular kind of tax arrangement regarding children and parents. Why? Well, for a number of reasons I've already tried to present before the court, and I'll present again, including the understanding of relational databases and relational databases insofar as they're used for financing, including and also in addition to relational databases as they're used by the government, and how that allows for misrepresentation of lineage, including parentage, that can be abused for a number of reasons. I contend it's actually being abused right now significantly in a major, major tax abuse that ends up disproportionately impacting children, including children that are also eligible for some form of generation skipping tax, i.e., there are certain elements, including in trust law, but also that have impact on things like annuities for retirement. It also include bestowal of benefits to beneficiaries through pension systems or life insurance policies that engage in, and also, by the way, also in connection with executive compensation packages that engage a process of generation skipping tax that I believe is also being massively abused and is being abused in a manner that has, I believe, national security concerns. But I bring this up because all of these matters are also connected to how, in the course of this opiate epidemic, that what we have is a refusal to actually hold people accountable for not only unnecessary medical treatment, but using prescriptions as economic events, including in connection with prescriptions for diagnoses that are not accurate, i.e., giving somebody the wrong medical diagnosis in order to enable some form of financial obligation associated with their medical treatment, including now, unfortunately, during the Affordable Care Act, under this illusory understanding that Medicare pays for our health insurance or that Social Security disability insurance pays for our health insurance. That's not actually true. Medicare is a trust. Social Security is a trust. And so when it comes to Medicare and Social Security, it also comes to taxation. And it also comes to tax abuse. And so in this process of so-called mandating that people get on health care, including involved with health insurance programs that they may not personally want or need under the auspices of somehow keeping costs down, I contend they've been completely disingenuous, that what they've really been trying to do is abuse the public trust by also abusing federal trust. Trust is very different. And part of what happened in the 1986 Tax Reform Act is that I contend they allowed for a pooling within the context of a trust of assets, including intangible assets, that should never have been mixed together, i.e., older generations of adults, including adults that were from the baby boomer era. It had to deal with specific kinds of socio-political changes. And it also had to deal with the United States at a specific period of time when things were rolling out around our financial regimes. Should not have been pooled with people that were, for instance, minors that were supposed to be covered by Social Security disability insurance. As a matter of fact, in the 1986 Tax Reform Act, there are a number of areas and a number of kinds of so-called childhood disabilities that were allowed to be accepted out of consideration for eligibility regarding Social Security disability insurance, and also how that impacted the relationship with the Medicare. So we've had this that had already started in the 80s, and by the time 96 rolled around, with the proposed universal health care efforts that had been going into effect, one of the things that happened in the universal health care package that had been proposed was, among other things, specific recommendations regarding pooled trust. Pooled trust for the health insurance. I contend that as part of what happened with that universal health care package, the one that was usually identified with Hillary Clinton, that something happened where they cut a deal connected to the specific elements of that healthcare package regarding insurance. Not just for health insurance, by the way. So, for instance, when they say, well, health insurance is different than other kinds of insurance, maybe in some ways it is, but when it comes to actual considerations functionally, including when it comes to pooling for the purposes of evaluating health insurance rates and or access to the benefits of that particular kind of insurance, I contend it's actually not so different. I actually contend it's actually the same, and that they were using health care to allow for a specific identification and determination of pooling that would not have been available to other other insurance sectors had they not already tried to mete it out under the consideration of health insurance. And so by the time September 1st came around, and what happened with September 1st regarding other aspects of the insurance industry, including the so-called terrorism risk insurance program, that we had already gone through a period where we had leveraged financial safety and national security on insurance, including insurance that would be provided in the event of a terrorist attack, and like it or not, in the event of a terrorist attack, the kind of insurance you're going to need is also going to include health insurance. And so by the time we get to the 2008 banking bailout, which was not just about 2008, right? There were several years where in the events that led to what was called the banking collapse that ended up leading to the banking bailout were in development. These are things that the insurance industry was already dealing with. And so when we had the Glass-Steagall Act aspects that had been dismantled, this is another thing that had come up in the 2008 election season, was the breaking down of financing, banking, and insurance operations when it came to the banking industry. That was a major part of how they were able to do what they did with the 2008 banking bailout. We'd already set the stage for another level of what I consider to be inappropriate and very, very harmful pooling for the purposes of insurance. Now we're in a situation where one of the things that's also happened is there hasn't been enough attention paid to the consideration of health insurance policies and other kinds of insurance policies, including group insurance policies for public pension recipients as reserves on municipal bonds, and how these kinds of reserves on municipal bonds function in connection with the financial solvency of the municipality and or the adherence to the actual terms of the financing regime that comes with accepting and or participating in some form of municipal bond or some form of municipal security. Many of these bonds include components that allow for the benefits that are provided to public pension recipients to be pooled, and or including in that pooling is to allow for it to be used to loan out as part of what is considered to be revenue for the municipality through that bond. But it also allows for the insurance policies themselves to be kept as a reserve. The question is, for what does one use a municipal reserve? And so these questions have been unfolding for a while. And so it's one of the things that comes up when considerations come into play of Well, where is the opiate epidemic happening? How many of the places where they've been identifying the opiate epidemic as being a sort of major crisis have been in urban areas versus rural areas? But how many of the areas are either in or not in zones and areas where there is significant investment in municipal financing through the form of a municipal bond? Because what's going to happen? Well, what's going to happen is the kind of insurance you get access to, even as a public employee, but even and not as a public employee, is going to be different than in the areas where there is significant public financing through the form of public bond obligation, regardless of whether it's a revenue bond or a general bond or some other kind of specific bond, including one that's based on infrastructure. And so the consideration of the kind of insurance, or at least in the early days, the matters in which somebody then is necessitated for drawing on either the insurance they have or some form of alleged insurance through the state marketplace. This makes a big difference. If you go through the state marketplace and you get access to a private insurance plan, that is different than getting access to a plan provided to you through Medicare. And question needs to be asked if they have allowed for the opiate epidemic, and especially the prosecution of the opiate epidemic, and what's been allowed to be considered recoveries on the opiate epidemic, to be meted out in the manner it has, because part of the investments that come with the expansion of the Affordable Care Act also necessitated some sort of manner in which they could prove that they were going to generate revenue. And so in the course of generating revenue, the question then becomes one of, well, what kind of assets do they liquidate in order to distribute so that then they can begin that revenue generation? It's one of the reasons why the racial implications are important, but so too is the political and historical context we put the opiate epidemic in. It's no small matter that presumably this opiate epidemic in the United States has happened concurrent to the war in Afghanistan and what has happened to Afghanistan in global opium production based upon the war in Afghanistan, and how that impacts what's been going on domestically, not just in relationship to opiates, by the way. But what I contend is a complete misrepresentation of the need for the kind of so-called prescription medications that people are given. I have acquired lots of evidence, and I've been examining for a lot of time. Doctors are not being safe, and they are not actually thinking about a patient's best interest when they keep stacking on prescriptions, including prescriptions that are contraindicated to other kinds of prescriptions that are given, and including in connection with what they're prescribing with opiates. This has been going on for a considerable amount of time, but as I asked earlier, how is this related to COVID-19? Is there a determinate increase in the amount of opiates that are being prescribed as a result of COVID-19, including in conjunction with other kinds of medications? And how does that correlate with reports on drug use that is not prescribed? Has there been an increase in non-prescription drug use, including by people that are working in connection with providing for whatever is considered to be the need associated with COVID-19? Or are we talking about a silent other epidemic that's not getting reported on? And in the course of that, is there room to say that the way that the so-called opiate epidemic was handled was actually a capital outlay? That companies, prescription medication, pharmaceutical companies that were targeted by those that were presumably prosecuting the opiate epidemic were writing off the fines and penalties they received for their role in the opiate epidemic in order to provide a sort of process for an outlay on later contracts they were going to get in connection with providing in association with what was alleged to be necessary for COVID-19. By the way, that also would include R&D. And then that would also include what kind of R&D are they getting? What kind of research are they getting that then is available outside of the pharmaceutical sector, up to and including other sectors? Including other sectors, one would have to bid through the federal government in order to acquire. And this is a more comprehensive situation. But I just want to say, is that what you did with my Michael Harrington? What I just heard? Is that what you did with my Michael Harrington? Why didn't you figure out or learn about who he was first, right? I mean, even if you take away all of the history he had access to, and even if you remove all of the people he had access to, what did you think you were going to do if you tried to translocate me in Appalachia during the opiate epidemic? That's a serious question. You're going to need to answer it.